We have an ongoing joke here, running joke here. All right, good afternoon, everyone. Welcome to the First Department. Welcome back to the First Department. If you haven't been here, this is really nice to see everybody back. Usual language, usual standard protocol. We give you ask for time, or we give you the time. The red light's for you, not for us. And having said that, we also want to let you know that we've read the record, know your cases pretty well. Needless to say, this may be a very hot bench. So that said, let's go through the calendar. First case, People versus John Doe.
Appellant requests 4 minutes and 1 for rebuttal.
4 and 1? Okay, 4 and 1. And, I'm sorry, 4? Thank you. American Transit versus Smart Choice. Your appellant's not here. Would you like to submit? Okay, thank you. Let's submit it. Next case, Tamara D. versus Lionel D. Submitted. National Auditing versus Salim Asa. No respondent. Would you like to submit? Yes, Your Honor. Thank you. Next case is Preserve BAMS versus Landmark Preservation. Where's the appellant? Are you the the Landmarks Preservation case? Going once? Any appellant? No appellant. Well, I think you want to submit this then? Thank you. Did I say something? I don't know. What did I do? Heredia versus CS Realty Associates.
Appellant, Your Honor.
Well, I must have said something. No respondent. You can submit?
That's fine.
Thank you very much. Oh. Did you guys put an ad out there? People versus Ventura. There we go. Helen? 6 and 1? 6 for respondent. I'll give you 5 and 3 and 4, okay? Republic of Kazakhstan versus Daniel Chapman.
10 and 5.
10 and 5.
Respondents.
You don't have to go 10. Because he asked 10 for doesn't mean you asked for 10. You know, so how much you want? 10? Okay, I'll give you 5 and 3 and 5. Don't forget the red light's for you, not for us, all right? Lexor Capital versus Altisource Asset Management.
Appellant cross respondent. 8 and 2, Your Honor.
8 and 2.
Cross appellant respondent 8, Your Honor.
All right. 5 and 3, 5 and 3. Thank you. People versus Corey Roby.
Request 5 and 2, Your Honor.
5 and 2. Okay, 5 and 5, 2 and 5. Thank you. Foundella versus West 345 West 70th.
For the appellant, 8 and 4. For the respondent, 5 minutes.
All right, it's 5 and 3 and 5, okay? Thank you. We have People versus Ramon Alfonso. Submitted. Woodward versus New York State Office of Children.
Respondent.
Care to submit? Yes. Thank you very much. 215 West 84th versus Bailey.
For appellant, Your Honor, 9 and 3, please. For the respondent, 7.
Okay, 5 and 3 and 5, folks. Thank you. Samash versus Bochi is submitted. It's a non-enumerated. All set. First case on the calendar. People versus John Doe. Okay, good afternoon.
members. David Clem for appellant Saquon Smith. There was a bevy of mistakes made at sentencing here that warrants a reduction in Mr. Smith's sentence. The principal one was the court's belief that Mr. Smith had not reported to probation, when in fact he had.
Was these arguments preserved? That was something in my notes?
The issue before your court is only the excessiveness of the sentence and how these issues affect the sentence that was imposed. Here, what was
Right, because he was saying that he was never told that there would be an enhanced sentence, right? I mean, that his sentence would go up,
That's right.
right?
And given the length of the sentence and where,
Counsel, has he completed his 2 years already?
no, he's got a few less than a few weeks left in the
Okay,
sentence, which is
so-
why what we're asking for is a reduction in the effectively the post-release supervision portion. He's still in custody.
When he got resentenced, didn't his supervision, his post internment or post, his PRS, right? It just wasn't coming, his PRS, wasn't that reduced?
There was no resentencing in
I
this
mean, when he
case.
got sentenced, wasn't he
He was given 2
originally-
years of post-release supervision
Right.
at the sentencing. The original deal was a 6-month jail sentence with probation. Instead, he got 2 years in custody, of which he's going to serve all 2 years, and then post-release supervision on the end. Therefore, this court's
Oh, I see, okay.
somewhat
right.
limited in what
Right.
relief can be granted. What we're asking for is,
You're asking for us to exercise our interest of justice power, right?
That's right.
Essentially, I mean, not essentially, that's it, right?
that's right. But this is a good case for it because of all these errors that occurred at sentencing.
But I understand that, but what about, I mean, you raise issues of his mental health, addiction issues. You don't think that PRS would be helpful maybe to an individual such as your client with the kinds of stuff that he's suffering from?
I think the 2-year prison sentence that was imposed was over-punishment for what happened here. What should have happened was that the original plea, a split sentence, should have stood. Now we're in a strange position where he has spent his 2 years in custody, and he's warranted.
But he didn't come back for his sentencing, right? He was warranted.
He warranted, that's right.
Right.
The court said he warranted twice and didn't come back twice. That was, of course, yet another error in this case.
But the fact of the matter is, he didn't come back for sentencing. He
He
had,
didn't come back. I mean, it was not a condition of the plea, which my friend acknowledges that was never once stated, that was a condition, but it is obviously a factor that this court can consider here. But the court, why it didn't give him the split sentence, every one of the factors the court relied on was incorrect and wrong. Unfortunately, his counsel did not correct it, and now we're here 2 years later with this record. But Mr. Smith, a 29-year-old first felony offender, whose only record in New York consisted of a misdemeanor, and has, as the court already noted, mental health and addiction issues. This is not a situation that the book should have been thrown at him for failing to appear. Thank you.
Okay, thank you, counsel.
Good afternoon, and may it please the court. Catherine Murata for the people.
So why shouldn't we exercise our interest of justice jurisdiction and maybe tinker with the PRS component of the sentence?
Well, as to the PRS component, defendant only received 6 months above the minimum, and as Your Honor said, due to his continued run-ins with the law and his failure to appear for sentencing, the PRS the length of PRS is appropriate here. Furthermore, due to the Less is More Act, he can earn 30 days of earned time credit for every 30 days that he satisfies his.
Counsel, did the defendant cooperate with the Department of Probation?
No, defendant, as a condition of defendant's plea, he was told by Justice Rodney that he had to get interviewed by the Department of Probation and answer all their questions truthfully. Defendant did not satisfy that condition, thus the court was properly enhanced defendants
How did he fall short in that respect?
to appear at probation.
Yeah.
Although he did appear on the for September 13th and through no fault of his own was not interviewed, he tried to appear 2 to 3 more times, but he said he was late and he never returned. The PSR also indicates on October 8th he failed to appear for the interview, and he admits himself that he was supposed to go 2 to 3 more times but failed to be interviewed because he was late, and then he never attempted again.
October 8th was the day before he was to be sentenced, correct?
The sentencing was December 21st.
No, I know, but when he absconded for the first one, correct?
Oh, yeah, I think it was October 21st. Let me just double check.
I mean, the record does indicate, unless I'm reading incorrect, there were opportunities for the defendant to correct some of the mistakes. I mean, this wasn't as if there was no opportunities here for him, right? I mean, the sense I get.
No, I mean, first of all, the claim is unpreserved. He could have objected to his sentencing enhancement at the sentencing proceeding. He failed to do so. And just taking into all the factors, he failed to appear at the sentencing proceeding. A bench warrant was issued. Although it was not an explicit condition at the plea, he was rearrested twice during the pendency of the case.
Can I ask you, counsel, were his mental health issues and his homelessness brought to the attention of the sentencing judge when she sentenced him?
Yes, all those factors were known to the sentencing court. In fact, the judge explicitly said that his attorneys zealously advocated for him. She was aware of all these factors. The PSR indicated them. So when sentencing him to the 2-year incarceration, the judge properly took all those factors in consideration. If there are no further questions, I ask that you affirm. Thank you.
Thank you.
2 factual issues I'd like to correct. The only missed appointment was one on October 8th. That appointment, the only notice my client got was mailed to his last known address. The record shows that Mr. Smith was in fact homeless. Enhancing his sentence for having missed that seems a bit absurd. My friend claims that there were run-ins with the law and he was rearrested twice. That's the same allegation that the court below made. That's also incorrect. There was 1 arrest in the interim with 2 charges. It was simple possession of drugs and trespass because he was sleeping in an abandoned building on a cold night because he was homeless. Those charges were eventually dismissed. Again, these are awfully thin reeds upon which to rest this greatly enhanced sentence.
But I guess the concern I have is that he may be someone who could benefit from PRS. In the original split sentence of 6 months incarceration, 5 years of probation, this is only 2 years of PRS. Isn't that a benefit?
If we ignore the fact that he has had to spend 2 years in custody, I would point out he's a first felony offender and he has managed to live a law-abiding life despite the mental
Well,
illness.
to my colleague's point, there was also the new statute. There's a holistic approach in terms of the PRS. It's no longer as draconian as it was before the statute, less is more being placed on it. So to my colleague's point, there's a more holistic and a different view in terms of what a PRS is supposed to do, and from what I gather, is to assist them. And the jury's still out on how effective this statute is working, but I would think that if it wasn't working, folks would be getting up here appealing, saying, no, it's not working, and we haven't seen that kind of appeal yet at that point, or those issues.
I'm not sure you'd get those appeals as a technical matter, but again, here...
The arguments we made, at least, right?
Again, I'm not sure the record ever includes
Right.
that information,
Okay.
unfortunately.
I got it.
But in this case, we would ask
Now
for
we're here.
a
Thank you
sentence.
very much. Thank you.
Thank
Thank
you.
you both. Samara D. versus Lionel D. Oh, that submitted? Yeah. Was that submitted? I think so. That was submitted, right?
It was submitted.
Yeah, I skipped that one, all right. Next one, national auditing. BAMS, that's right. BAMS versus Landmark, how much time, where's the appellant? Oh, there we go. How much time do you need? Appellant?
He must have showed up. He was here, he showed up.
Respondents?
5 minutes, we have 4 minutes on behalf of.
Okay, so it's 5 and 3, 5 and 5, okay? Thank you very much. So why don't you guys come up? You're up.
Good afternoon, Your Honors.
Counsel? You gotta get to the mic, pull the mic down.
I'm sorry.
Nope, apologies. Here we go.
Can you hear me well?
Huh?
With the time that's available, maybe I should ask whether you have any particular questions.
Well, first identify who you are, so that we know who you are for the
Michael
record.
Gruen.
Thank you.
I represent the petitioners.
Sir, was a certificate of appropriateness ever issued before this petition?
That's a very good question. Not officially, in the sense that the Landmarks Commission denies that it has ever been issued. In fact, it was, as a matter of law, issued the moment that the vote was finished among the commissioners.
But isn't the argument, sir, you make inconsistent with our case law in this department? Specifically, it's the Committee to Save Beacon Theater. Isn't this case on all fours with the Beacon Theater case?
With the what?
The Beacon Theater case.
I would beg to differ on that. The case you recite is a very special situation. It was a 25308 case where the issue is, I hope I have the number right, the issue is a hard financial situation for the owner and need for going through a whole procedure involving outside groups such as in the financial department of the city to work out an arrangement. And if you go through the record of this at the lower case, the lower case, not the appeal, but you'll find that it was a very lengthily considered case and not at all of the nature of what you would be used to in such a case. In my opinion, it's totally.
But in that case also, there wasn't a certificate of appropriateness, as my colleague suggesting that we don't have here, correct?
I'm sorry, there wasn't
No certificate of appropriateness in Beacon Theater. And isn't that precisely what is occurring in
Well,
this case?
if I understand you, the case went on for a very long time, and ultimately they couldn't reach a deal on it, and it vanished.
So counsel, I have a question. Since you're not the certificate, the COA, you need the COA. The developer needs a COA before it can actually put a shovel in the ground, right?
Yes.
You can't do anything. So in this case here, is it the Brooklyn Academy of Music area that they want to redevelop certain parts of the Brooklyn Academy of Music? Has the shovel hit the ground yet?
Well, if I understand you, this case starts with a request for a certificate of appropriateness.
Right.
The whole case was handled on that basis up until the very end of it, after the vote had been taken in the manner of a regular, ordinary C of A case, and suddenly the city claimed that it's not really, it's a different type, which is created by a remote case, or rather.
So no, well, I think the concern here is whether or not there is, with no COA, without a certificate of appropriateness, nothing can go forward.
Yes, but a
And you're-
D
and
of
you're-
A,
And as my colleague asked at the first sentence, was there a COA? You're like, well, maybe. I think the answer was, we're not sure.
oh, I'm very sure.
That there was a
I'm very
COA.
sure my opponents are wrong on that issue.
How is it that there is a
well,
COA then?
I started answering this by pointing out that it was treated from beginning to end as a C of A case, and it changed in the eyes of the commission only after the vote had been taken, and the vote under law
Okay,
is
I think-
a
okay, I think
final.
Let's hear from
act
let's hear from the respondents and see if we can tie up the loose end here. Thank you. You have 3-minute rebuttal time.
Thank you.
Good afternoon, Tahira Sadria appearing on behalf of the Landmarks Preservation Commission of the City of New York. The facts and the arguments presented here are almost identical to those presented in the Committee to Save Beacon Theater.
So do we have a COA?
We do not have a certificate of
Am I
appropriateness.
incorrect in saying that nothing can be done without a COA?
That is
You can't
correct.
put a shovel in the ground without a COA. So this is the Brooklyn Academy of Music looking to redevelop certain portions of its structure, I guess?
So there's a new, no, not exactly, there is a new structure is going to be constructed near to the Brooklyn Academy of Music, and there will be additional
housing?
classroom space, and then a portion of the building is going to be used for residential purposes,
Right.
for apartments.
Okay, and no shovel in the ground?
No shovels in the ground, no.
What's left before the certificate of appropriateness is issued?
So, I mean, this petition was taken,
I'm asking you
Okay,
what's
right now.
left, right? You
Right.
wrote a letter that we preliminarily approved, but we need some other stuff.
right. So
What's left?
So then after that, then the developer had to work with the commission staff to resolve the issues in terms of like modifying the entranceways to make them more low-key and consistent.
Has that all occurred?
And that part has occurred, and then it needed to go to the Department of City Planning, and they needed to approve a special permit to allow for additional zoning on the lot. And then the the City Council had to approve
Is that
permit.
done?
My understanding is that has happened since this appeal has been taken.
So what's the process?
so-
When do you get all these approvals back and then take another vote? How will the petitioners know that there's a final determination?
There will be a, so then the developer still has to then file the plans, the construction drawings with the Department of Buildings, and have approval by the Department of Buildings,
Right,
and
let's
then,
say all that happens, what gives the petitioners notification that this is now a done deal?
there is a final certificate of appropriateness is issued.
Is there a vote taken again, or do you just get
If
up on
there's-
a meeting and say, okay, this is, all the rest of this is done, now let's issue the certificate?
My understanding is that if there is no change in the interim, like if there had been a change in what the design was permitted by city planning or by, then there would need to be a revote. But if there is no substantive further change, then the final certificate of appropriateness is issued by the commission staff after having reviewed.
And how will the petitioner know that that happened? Does it get published anywhere? Does the commission tell anybody?
I mean, I think it's a public action. I mean,
Well, isn't there a hearings, like with eminent domain?
No, that's why
In other words, won't
there's not.
won't the petitioners here have an opportunity to be heard in this process? In other words, the way I see it, there's no finality yet.
Yes, there's no
They
finality.
haven't been
yes.
harmed. In other words, this whole process is premature.
That's correct.
So somewhere in this process, they will have the opportunity to object that shadows and all the other things that the community is upset about.
I mean, I think that at the time that I mean, they have had an opportunity to comment on the plans that have been issued. And there would have been, I believe that there would have been a time to comment on the city planning process. Once the,
Look,
I mean, I don't believe that there's
Counsel,
another.
the bottom line is, until that COA is issued, anything can happen.
That's
Once
correct.
the COA is issued, that's when it's ripe and that's when it's locked down.
That is correct.
Because up until that point, whatever,
Yes.
whoever, however it
Yes,
participates, whatever.
there's a lot of change.
There are a lot of moving parts, as my colleagues have seemed to intimate, right?
Yes.
So once that COA is issued, and I
Yes.
can't believe that something as big as this is not going to be in some sort of public registry.
Yes, it would definitely,
to
it's a
notify,
public, yeah,
right?
it's definitely.
That they're going to know, and that's when the challenge can come in, because no other changes can occur at that point once the COA is issued.
That is correct. Yes.
Is it possible that a COA will not be issued?
It is possible that a COA of A will not be
Like
issued
the
for
Department
various
of Building
reasons
says, no,
the-
we're not,
yes.
we're
The
not
department-
doing a
The
rezoning
financing
or
falls
whatever.
through and they don't go
Okay.
through with it, yep,
Okay, thank you.
yep.
Good afternoon, Janice McAvoy from Fried Frank on behalf of the intervener owner 130 St. Felix Street LLC.
And now you get your chance to respond, right? I was watching you, were getting very animated.
I'm animated, I'm always excited about my case.
How are they going to know the COA gets issued?
It is published by the Landmarks Commission. It is published on their website. Anyone who accesses it knows this is something that has been followed widely in the press. It will be.
It's transparent. There's no
It
one
is
that's going to be able to
very
argue that they
transparent.
didn't know it was in the dark of night that this guy issued and the days elapsed and I can't now bring a challenge.
Absolutely not, Your Honor. It's very open and very transparent.
Also, up to now, the commission's been pretty clear that it has not yet issued any permit that would allow construction to go forward.
Every single document that was filed, the update approval letter to the owner specifically said, this is not a permit. No work can commence until a certificate.
And that was the case in the Beacon case as well, right? And that was
Exactly the
another
same.
indicia of that it was not yet ripe.
Exactly, Your Honor. The only characteristic that is different between Beacon and this case is that Beacon involved a certificate of appropriateness for an individual landmark. This is a certificate of appropriateness for a historic district. There is no substantive difference. There was a miscitation in the appellate division, one miscitation among many citations to the landmarks code. The case was about a certificate of appropriateness. It was not about a hardship declaration, and even that wouldn't matter. The issue is no final certificate of appropriateness has been issued. Any further
Okay.
questions?
Thank you.
Thank you, Your Honors.
Okay, counsel,
I'm sorry.
you have rebuttal time.
The discussion has put a finger on exactly what the problem is. This starts 3 years ago, and the first thing one would think of if it were, for example, a secret issue, is that one has to look at what the problems are with what has been proposed before it gets out of hand, and you don't have time for doing that anymore.
Well, that's the concern is that at least the issues that we're looking at is that this still is in a very fluid process here, is that you can't make any, at least in my mind, the challenges aren't ripe yet because we don't know exactly what we're dealing with yet. We're still waiting for, from what we can see from the record here, DOB approval, because they may just say, no.
You know, so far as I'm able to tell, there has not been a whit of a change on anything for the past 3 years. It's obvious from the beginning what is going to happen.
We haven't had DOB weigh in yet.
The problem is that after 3 years and full development of everything regarding the case to the person who provides the steel is over, and I have to find that out and start a proceeding immediately. And what do you think the feeling about that is likely to be in the commission? We've done it. We've been through all of this. Don't bother us. It is important to have public involvement in this kind of issue. Very important. It affects, in the case of a historic district.
So, counsel, does that mean we just throw out the concept of final agency decision? Don't we have to wait for a final agency decision before we bring it Article 78? Are you just saying get rid of that requirement?
As I've suggested to you, the final decision, as a matter of law, it says so in the law itself, is the moment that the
Landmarks?
the certificate of appropriateness is voted. That is in the law explains all sorts of things about the procedure. It then says, and upon the signature of the vote being taken, that is the end. That is the...
But that argument seems to be inconsistent with the Beacon case, because there, essentially, there was no certificate of appropriateness, and therefore we said that finality was lacking. It seems to me that we're in the same circumstance here.
I wish I had gotten that better. I'm sure it's well worthwhile.
Thank you, counsel. Thank you all.
Thank you.
We'll take it back and look at it. Thank you. People versus Ventura.
Thank you. May it please the court, Robert Hunter for Mr. Ventura. The application to search Mr. Ventura's apartment said absolutely nothing about any ongoing or continuous criminal activity for almost 2 months before the warrant was authorized. It was highly unusual in that there was...
Your argument, correct me if I'm wrong, is there's a staleness argument, right?
Exactly, Your Honor.
The time that the warrant was issued, well, the warrant was issued the same day that they confirmed the address of the defendant, correct? But it was 7 weeks from the point of the last robbery.
The warrant was issued about 7 weeks after the last robbery. Mr. Ventura was identified by an eyewitness about a week before the warrant was executed.
The victim identified him, no?
Yes.
Okay.
Yeah.
When you say eyewitness, that doesn't mean the victim. The victim identified the defendant in a lineup.
Yeah, the complaining witness,
right.
Exactly.
Right.
So there is no record in that intervening 7-week period of any attempt to connect Mr. Ventura's apartment to the items that were stolen.
Counsel, doesn't it matter that the property allegedly stolen and that was sought in the warrant was not ephemeral? It was not. It's not the kind of evidence that dissipates or degrades, like drugs, for example.
So 2 points on that. The first is that a good portion of what was sought in that warrant was ephemeral. We're talking about credit cards, passports, the police shield that is attempted.
Sneakers.
There were sneakers too, and I'll get to that. But there a lot. This is, as alleged in the warrant, a sophisticated criminal enterprise during the space of a week, and then it stops. And I can't imagine any reason why it would just sit in someone's apartment for almost 2 months after that criminal activity stops, when the only inherent value...
Why wouldn't it be reasonable reasonable to conclude under the circumstances that there could be or there would be contraband hidden in defendant's residence. I mean, where else do you naturally keep possessions or keep things, if not in your apartment?
So there is no, if the court upholds a gap of that length of time,
But
just
the gap,
because
but see,
this
but
is
I guess where I'm
household
having a
items-
problem with your argument is that my understanding of the record is that the search warrant was issued within a few days of defendant being identified.
That's correct, but that,
So shouldn't we be looking at it from that period of time as opposed to what you say 7 weeks earlier when the robberies were committed?
no, Your Honor, because the analysis for staleness doctrine is whether the search warrant sets forth facts that are so closely related to the time of the issue of the warrant to justify probable cause at that time. So it doesn't matter what point he was identified in, and police should have done an investigation to corroborate any connection between the apartment and the item stolen. They could have checked to see if the car that was alleged to be used in that robbery was parked anywhere nearby. They could have talked to other people in the building. They could have seen whether there were suspicious people or property being moved out of that building. The warrant says nothing about that, and the warrant also says nothing about any criminal activity after the final of these 3 robberies on November 29th, which is an almost a 2-month period. And as I understand that question about it, the items being, not ephemeral, the fact that there were some household items stolen here can't be a blank check to not have any outer time limit on a warrant when there's absolutely no sort of criminal activity that's alleged to be ongoing. And the courts, when there has been no investigation in the record, New York appellate courts have required some sort of special affidavit from detectives.
Counsel,
or
did you make
others.
that argument below? Did you make the argument below that we had to look back to November 19th?
Yes. So in the second motion to controvert, Mr. Ventura's trial attorney said there would be no reason to believe the proceeds of this alleged crime would be found in Mr. Ventura's apartment 2 months later. So that 2-month period, November 29th to January 16th.
What was the basis of the second motion to controvert?
Staleness, Your Honor.
On the basis that,
That the period between the robbery in which Mr. Ventura was identified
Right.
and the execution of the warrant and the warrant application, it's exactly the argument that I'm making here.
It's not so much staleness as more along the lines that there was no basis to believe that the stolen property would be there, right? I mean, that's it.
Yes, Your Honor. I
I'm just
I
saying
think
the
it's-
property wasn't going to be there. There shouldn't have been a search warrant. But as my colleague said, this is not the type of evidence that's ephemeral, that's going to dissipate and disappear. Well, they can flush it down a toilet. It's not going to happen.
I mean, respectfully, I think that if someone's stolen credit cards or passport, I would imagine there's an incentive to get rid of that. I can't imagine any reason why some of that would stick around. But to your question, it's both. There's no connection to begin with, other than the fact that the police believe that Mr. Ventura was involved in these robberies, and the fact that he lived there, and there. Then nothing for 7
Okay.
weeks.
Thank you. You have rebuttal time. Thank you.
Good afternoon, David Gagne for the People. 3 judges below have found that the search warrant issued as part of an ongoing investigation was supported by probable cause in this court.
How do you respond to the argument that we should be looking at really essentially from the time of the incidents, the 2 months or several weeks, as opposed to maybe from the time the defendant was identified? What's the appropriate period of time to look?
Well, it's certainly relevant that the victim only identified the defendant 1 week before the issuance of the warrant, and in fact confirmed that the defendant was living at the residence on the same day that the warrant was issued. The police really couldn't have obtained the warrant any sooner than they did. And so in addition to that, the affidavit was not stale for 2 additional reasons. First, it provided reasonable cause to believe that the defendant had committed not just one, but rather a series of police impersonation robberies within the span of less than
Why
1 week.
was there a reasonable cause to believe 7 weeks later that the credit cards, passports, sneakers, et cetera, would still be in the apartment?
Well, as your honors have already pointed out, the nature of the property was such that it was likely to have still been in the defendant's apartment. The warrant authorized a search for items like sneakers, headphones, gold chains. These are all items that the defendant could have readily kept for any length of time. So there's good reason to think that 7 weeks later, they would still be in his apartment.
Parenthetically, there was no misidentification issue here.
There was absolutely no misidentification issue. That did not come up until sentencing. That was well after the warrant had already been issued. And of course, we're only concerned with the facts that were known to the court at the time the warrant was issued.
It sounds like what the appellant is arguing is some sort of bright line rule when it comes to now, if we were to agree with the appellant, 7 weeks would be a clear departure, and that would invalidate the search warrant because 7 weeks is too long for any kind of evidence, be it the ephemeral or be it the kind that you can't get rid of. It doesn't matter. That's what it seems like what the appellant's pushing for, right? Because if we agree with him, that would be the bright line rule, which I'm not so sure that that's something that, you know, there's a lot of moving parts when it comes to a search warrant and the evidence, right?
Yeah, that's correct, Your Honor. The courts have repeatedly affirmed that we need to look at the totality of the circumstances.
Right, because what's 8 weeks, what's 9 weeks, what's 4 weeks? I mean, you know, but it all depends on circumstances, what's going on, and it all has to develop at the trial level in terms of when they controvert the warrant, right?
That's correct, Your Honor. Unless there are any further questions, I ask that you affirm. Thank you.
Thank you.
So if I could first address the bright line rule question.
Yeah, that would be, I mean, that's essentially what, if we were to agree with, in that argument, then we would be establishing with this particular case, a 7-week rule, that if it's 7 weeks or longer, the search warrant in itself is prima facie, should be invalid.
It's not a bright line rule because 7 weeks would be okay had there been any of the police investigation that.
Oh, but that's not how it's going to be seized upon. If we issue a decision that says 7 weeks, that's going to be looked at as 7 weeks as a bright line rule.
Well, Your Honor,
and that takes away a lot of the, you know, the arguments that go below in terms of controverting the warrant.
So we cite in our briefs.
It's a harder case for the people to get over. You got the 7-week rule, and that's like, okay, now we're already got one strike against us.
All they had to do was establish some sort of either ongoing activity through investigation, or, if, for example, in some sex crimes
Well, that's
case,
all
there's
has to
been
be. Well, that's all should be brought out at the hearing court, before the hearing court, right? What you're describing.
I'm not sure I understand.
Well, what you're saying, all they had to do was X, Y, and Z, right?
All the police had to do in supporting the warrant. This problem could be solved by more detailed warrants and more detailed investigations. And to the extent that Your Honor views that as a bright line rule, then the third department already has one in People v. Acevedo, which we cite in our briefs, where when there was no ongoing criminal activity and no affidavit as to, you know, the ephemerality or anything like that of the evidence, 2 months was too much.
So how about, counsel, how do you distinguish People versus Hernandez, which is the second department that rejected a staleness challenge for 4 months had passed because the nature of the property was like clothing and defendant's clothing and stuff like that. This seems very close. This case seems very close.
It's different, Your Honor, because People v. Fernandez was a murder case, and it was the clothing that the defendant owned. So I concede that clothing that I own will be at my apartment, but not clothing that.
You think there should be a difference between clothing that or stuff that you steal and stuff that you own? That's the difference in the staleness analysis?
Well, it's a totality of the circumstances test, as we've discussed. And what I'm saying is, or excuse me.
No, I'm just trying to figure out what more. I mean, they go to the once they get the address, they get the warrant. They don't have the address for 7 weeks. The third victim identifies the defendant, They find his address, and then they go to the home as quickly as possible, correct? It's not like they waited another 3 weeks. They got the warrant. So
Right,
what more are you saying that you think needs to happen?
Well, they need to confirm that there's actually a connection between the apartment itself and that's
Well,
the
so
reason to
that,
believe
I
there's
guess, is
stolen
what I'm
property.
asking you. Aren't there a lot of cases that say this kind of stuff is generally in that kind of place in all different contexts, not just People versus Fernandez, but other second, first, and third department cases that basically say these type, I think my colleague was talking about proceeds that are not going away or not disappearing, reasonable people could assume that they would be at the defendant's place of where he lives or she lives?
Your Honor, there's certainly cases where the court on the specific facts has found that, but I would just want to note that there's no bright line ephemerality rule, and the Court of Appeals opinion in People v. the Fourth Department's opinion in People v. Lowell, it was a coin collection. That's almost the opposite of an ephemeral item, and they said it could have been as much as 4 months had passed, and that's too long. So,
Okay. Thank you. Thank you both.
Thank you.
Republic of Kazakhstan versus Daniel Chapman. Okay.
May it please the court, Felice Gallant from Norton Rose Fulbright. On behalf of the appellant, I have with me Matthew Kirtland, also of Norton Rose Fulbright, admitted pro hac vici, and requests that he be permitted to participate in this appeal.
Okay, thank you.
Thank you, Your Honors.
Welcome to the first
Matthew Kirtland, Norton Rose, Fulbright for Appellant, Republic of Kazakhstan. We're here today, Your Honors, on an appeal from the trial court's dismissal of my client's complaint against the defendants for failure to state a claim. There are two principal reasons why the trial court's ruling is an error and should be reversed. First, contrary to what the trial court said, this case is not a collateral attack on any international arbitration award. Second, contrary to what
If it's not that, what is it?
Thank you, Your Honor. This case is a cause of action under New York law for aiding and abetting and civil conspiracy, as well as under English law for unlawful means conspiracy, to hold the defendants.
But it's all arising out of the transaction that occurred with status, right? Or am I incorrect?
The fraud that the defendants are aiding and abetting and conspiring to commit does arise, and it was committed and is continuing to be committed by non-parties to this case, the Stati parties. That's correct, Your Honor. But that fraud, as alleged in detail in the complaint, far exceeds and transcends the international arbitration.
But so here, that's the problem, right? If I give you half the fraud in the arbitration and I don't give you the other half, I don't get to come back later and talk more about the fraud. The fraud was litigated in the arbitration. It was litigated in the Swiss courts. It was litigated in several courts, correct?
Incorrect, Your Honor.
No, let me say this, not your particular aspects of the fraud, but the fraud of which you are complaining was not raised in the arbitration.
Correct, Your Honor.
Was it raised in Switzerland?
In Sweden.
I'm sorry, Sweden. Ugh, Sweden, right.
There was, you take the current fraud that is now known.
No. You can't parse it out. It's fraud. It's fraud. Maybe there are three aspects of fraud, but it is literally the Stasis did all these fraudulent things which make the arbitration award unsatisfactory, correct?
No, Your Honor, that's not the allegation of the complaint.
Let me just say this. Is that not what you argued in Sweden, that fraud permeated the arbitration award?
In Sweden, which...
That the Stasis committed fraud that permeated the arbitration award.
That was not the argument, Your Honor. Just so I could clarify. This is the key to the...
Okay. What did you argue in
the
Sweden?
question. During the arbitration,
In Sweden, what did you argue to the Swedish court?
Midway through the Swedish proceedings, which went from 2015 to 2016, the Republic, through a 1782 in New York, discovered one small shred of fraud, Your Honor. And it is
I'm going to
important.
ask you again. What did you argue to the Swedish court?
In the Swedish court, the argument was that we had uncovered evidence
Of
that
fraud, right?
of one element of fraud, Your Honor.
Doesn't matter how many elements. You argued that you uncovered fraud,
Yes,
correct?
correct.
And the Swedish court dealt with that argument, correct?
The Swedish court dealt with those allegations under Swedish law under
Now
demurrer
you're
standard.
saying there's more evidence of fraud.
Different frauds, different law, Your Honor.
How is the fraud different?
In Sweden, we did not know that the audit opinions for the study's financial statements
How
were
is the
obtained by
fraud different?
So it's part of the same fraud, essentially, what you're arguing. You're saying that some of the fraud you knew and the other part you didn't, correct? I mean, that's the argument. We discovered it later. So why shouldn't, if that's your argument, why shouldn't we apply collateral estoppel to that?
apply collateral estoppel.
Yeah.
Because to apply collateral estoppel, Your Honor, the issue has to be fully and fairly litigated and squarely decided. And here, if our causes of action in New York were under Swedish law, then there would be an argument. But the case law is clear that decisions under non-New York law do not create collateral estoppel under New York law. And that's undisputed. In addition, Your Honor, as we allege and has been held by other courts, the Swedish decision, which Your Honors are referring to, was itself procured by material misrepresentations. This was discovered in 2019.
What about the DC court? What did you argue in front of the DC court?
The DC court was the same limited fraud put to the Swedish court, and that was not.
I don't understand how you can parse out fraud. Fraud is fraud. If there's more evidence of it that you wish you had before, that doesn't mean that it's not the same fraud. If you don't have the underlying fraud, you can't have aiding and abetting it here, correct? You can't bring an aiding and abetting claim to bootstrap a claim that you already bought in DC and in Sweden.
Your Honor, this exact argument was made to the same DC court that confirmed the award, and that judge, Judge Amy Berman Jackson, when the defendants made this exact argument and she rejected it, she held, as we allege in the complaint, and as is clear on the record, her decision only touched upon one element of fraud under different law, and she rejected their argument. They made the same argument in the SDNY before Judge Kodal, and he said there was a tenuous connection between these claims and the underlying arbitration. There is, under collateral attack and collateral estoppel, no law and no basis as alleged to say that our claims here, which have been validated in other courts, have already been litigated and decided.
Okay, thank you. You have rebuttal time.
Thank you, Your Honor.
May it please the court, Clay Pierce from Faegre, Trinker, Biddle, and Reith on behalf of the Argentan parties. I'd like to focus on the collateral attack issue, which was the subject of Judge Brock's or Justice Brock's opinion.
Counsel, how can this be a collateral attack, really? I mean, the result, any result from this lawsuit will not affect the arbitrable award, correct?
It doesn't have to. You don't have to seek the relief of vacating the award for it to be a collateral attack.
I would spend your time more on collateral estoppel. That's just one person's opinion.
Could I, Your Honor, just refer you to one decision?
Please.
Kramer Wilson Company versus National General Management Company. 3 members of this panel sat on that case, specifically Justices Moulton, Scarpula, and Singh. It was functionally exactly what we're dealing with here. A party said that a non-party to an arbitration submitted false evidence to the arbitration panel. It was not a case to overturn the arbitration award. It was a case for damages, a damages claim brought against a non-party based on the concept or based on the theory that the underlying arbitration had been procured by fraud. This court affirmed dismissal. This court said it was an impermissible collateral attack. In rendering that decision, this court cited to Vinokur versus Penny Lane Owners Corp. For the following proposition. This is really important. A litigant's remedy for alleged fraud in the course of a legal proceeding lies exclusively in that lawsuit itself, not in a second plenary collaterally attacking the judgment in the original action. They can bring their claims for fraud to Washington, D.C. That is where the collateral attack doctrine says a party has to
Okay,
go. That's a
let's move
direct
on
attack.
to collateral estoppel, right? That's really what I would like you to focus on. Do you think that this new suit is barred by collateral estoppel?
Absolutely.
Why?
Because the issue of fraud was addressed by the Swedish Intermediate Court of Appeals and by the Swedish Supreme Court.
And was it also addressed in the Swedish arbitration?
It absolutely was addressed in the Swedish arbitration.
So if there was more, so this is just more, there's no claim here that these defendants were a part of the fraud, right? The claim is that they aided and abetted the fraud that was litigated in the arbitration and then in the Swedish courts. And was that also litigated in the DC court?
Yes, it was litigated in the DC court. In the original, I'll take each of those in turn if I may. In the original arbitration, there was a tremendous amount of fighting about whether or not the economic numbers being handed over by the Stadis for the value of the assets that Kazakhstan stole were reliable. They actively litigated the issue. Kazakhstan said that the Stadis were lying. The arbitration panel ultimately focused on a bid for assets, said that was a commercial event that preceded the litigation, and they thought that was a reliable indication of damages. When my opponent went to Sweden and said, you should overturn the award, he said they lied about damages in the arbitration, and we've also found out that they've been lying about their finances for these companies. They lied in their financial reports. Given all these lies, you absolutely have to vacate the award. And the Swedish court said, no, we won't. Because at the end of the day, all of these business transactions they're talking about happened before the arbitration and were not presented directly.
So this lawsuit sounds like, or at least from based on your argument, based on the record, sort of like an end run because they're going after the non-participants of the arbitration.
That is exactly what it is. And I know that just
if we can't go after the actual participants, maybe we can creatively now go after the non-participants because as an aiding and abetting claim so that therefore we're arguing it's not collateral estoppel. These folks were never part of the proceedings. It's wholly separate.
Yes. Yeah.
But they were still the non-parties. The defendants here were still sort of on the peripheral because they were also there.
Let me be clear. Collateral estoppel applies to
non-parties. Does collateral estoppel apply to the circumstances your adversary is arguing that there was one piece of fraud? We've now discovered other additional aspects of fraud which have not been ruled upon. Can your adversary raise that in this lawsuit and not be bound by collateral estoppel?
No, he can't because collateral estoppel applies to issues. It doesn't apply to new facts. There are always new facts. Whenever someone comes back to court, they always say, I've got new facts. And that's the reason why you can't make the prior award preclusive. It doesn't work that way. There has to be an end to
So if
this.
we were to agree with the appellant here, that'd be really sending a signal out there that if you can't get something directly, go through the other way. Go sue or commence actions against other non-parties and that we can go forward that way.
Yes, and I want to be clear that in the, going back to collateral attack with respect to Justice Scarpool and the rest of you, but the collateral attack doctrine has been relied on by this court on innumerable occasions to dismiss cases against parties that weren't in the original arbitration. What do people do when they lose an arbitration? They sue the arbitrators. They sue the AAA. They sue witnesses. They sue anybody they can sue. They're being creative. He's being creative. And the courts again and again say, if you're saying that the arbitration proceeding was procured by fraud, was tainted by some misconduct, there's two options. One, get the award vacated, or two, oppose confirmation. They did that, they failed. If they want to raise these fraud claims, they can do it down in the district court in DC. When they filed this appeal, they simultaneously filed an action down in the district court in the Washington, DC to reopen those proceedings. He can make all of his arguments there.
Thank you, counsel.
Thank you.
Thank you, Your Honors. There's critical points on the record that need to be clarified. The fraud that is alleged here The fraud that was alleged in the Swedish proceedings.
But isn't it, what I mentioned, did you hear what I said? I mean,
Yes, Your Honor.
your clients were, the defendants that are being sued here were non-parties to the arbitration. They were sort of in peripheral. They were sort of there. The fraud that was that's being alleged that were committed by the folks who were part of the arbitration, the defendants here were sort of tied into those, to one of the parties there. Isn't this attempt now to be like, instead of going, is this a backdoor way of trying to relitigate something that you couldn't prove in arbitration?
No, Your Honor. 2 reasons. One, the fraud was not discovered before 2 years after the arbitration.
But if it's issue preclusion, it's issue preclusion, as your adversary argues, not new evidentiary facts, what does it matter? You're precluded by collateral estoppel.
By which decision, Your Honor?
I'm telling you, if the basis of collateral estoppel is issue preclusion, so
Yes.
why should you be permitted to now raise additional claims of fraud, which frankly tie into all the other claims of fraud that were litigated heavily in the European courts?
In our favor, Your Honor. At present, the Belgian Court of Appeal has validated the fraud. It has been validated in the Netherlands. The studies have been indicted for the
They've
same
won 3
fraud.
times, you won 3.
No, Your Honor.
It's 3-2.
No, Your Honor.
Well, wasn't Italy, didn't the High Court in Italy support the arbitration?
The High Court in Italy rubber stamped the Swedish decision.
So that's your characterization.
No, that's what the decision says. It says, if the Swedish court has rejected annulment, then that's it for us. But in England, Belgium, Luxembourg, the Netherlands, after the full fraud case.
How about in DC?
In DC, Your Honor, the fraud was not admitted.
Was the arbitration award confirmed in DC?
Absolutely, Your Honor.
Okay, so, all right. So here in the United States, the arbitration award has been confirmed.
Absolutely.
It was confirmed in Sweden.
It was
confirmed in Italy. So again,
But on issue preclusion, Your Honor,
well, let me ask you, how do you distinguish matter of Hirsch, Cooper, 181 AD 2nd, 5255? You can't go back and add new stuff, new facts into an arbitration award, because essentially you would read, the whole point of arbitration is not to do this. You are literally doing what the arbitration is supposed to discourage, which is go back and relitigate and relitigate and relitigate something that was litigated with new facts and better proof.
Your Honor, it is an undisputed fact on this record that this fraud was not litigated in the arbitration. We can talk about Sweden courts and DC courts, but it is an undisputed fact that the first evidence of the fraud was not discovered until 2 years after the arbitration
Did you not
ended.
controvert the numbers that you are saying now were fraudulent in the arbitration?
There's a difference between arguing damage. Yes.
Yes, of course, but I would prefer if you first answer my question and then say whatever you want to say.
Damage claims were controverted, but not on the basis of fraud. So for issue preclusion, black letter law, the issue has to be asserted and squarely decided. And this is the point, Your Honor, if I could just close just briefly.
You got 5 seconds.
DC has confirmed it didn't decide the fraud and didn't admit it. Sweden is a demurrer standard under Swedish law that does not act as collateral estoppel. The English Court of Appeal has held this, the Belgian court has held this, and even if everything my opponent was saying is true, which is contradicted by the record, even if that's true, there are court findings and it is factually alleged, and they can't contradict it here, that this Swedish decision on which the court is placing so much reliance in oral argument was itself, not the arbitral award, the Swedish court decision was obtained by misrepresentation. It is not entitled to collateral estoppel. And they can't contradict the facts alleging that in this stage.
Thank you.
Your Honor.
We got everything. Thank you very much. Thank you both. Luxor versus Altasauce. You folks have 5 and 3, 5 and 3, okay? Just to remind you.
May it please the court, Darrell Cafasso from Oric, Harrington, and Sutcliffe on behalf of the appellant cross-respondent Altasource. The question on this appeal is whether Luxor, a highly sophisticated investment management firm that made a preferred equity investment in Altasource, is entitled to a redemption right that it never contracted for.
What does all but not less than all mean?
It can only mean one thing, Your Honor, which is if there are legally available funds,
Right.
that outsource has the obligation to redeem all but not less than all. What they're asking for here is a partial redemption right that they did not bargain for. Now, that exact right is a separate right, and it's often found in these types of
Why can't it be interpreted as also being by saying, well, you know what, they can pay us what they have and then pay us later on what they owe us?
Because that is exactly the right that they did not bargain for. And I would direct your attention to page 25 of our opening brief, where we contrast the language in this certificate with the language, two examples in other preferred equity cases.
Well, also you have, internally, you have 6A sub I, which is about redemption of common shares.
Your Honor, these are highly sophisticated parties. When they wanted to deal with a right involving less than all shares, they knew how to do it, and you're exactly right. If you look at Section 6, which is the conversion right, it provides for a partial conversion. This contract...
So they want it both ways. They want it all or nothing. They want it all or nothing, and if you can't give them all, we want something.
Well, it's a different right, Your Honor. They want a redemption of all, and that's all the contract provides for. They also have the right under this contract to convert their preferred shares into common shares, and there the contract uses the language some or all. That language is nowhere found in Section 5, which is
But there's a redemption, right?
Correct. And I'd also point out, Your Honor, if there's nothing remotely unfair or unreasonable about holding a sophisticated party to the terms of its contract. It is black letter law, going back at least a century, that redemption rights, even when they're labeled mandatory, are never absolute. That is because preferred equity is not debt, it's presumptively permanent capital, and it's always subject to the final financial condition of the company. What they're asking this court for, and their papers are a little bit hard to follow on this, but I think what they're asking this court for is a ruling that whenever a company receives a redemption request and does not honor it, it's in default. That ruling would fly in the face of literally a century of law.
If they wanted that kind of remedy, couldn't they have provided for a default under those circumstances?
Correct. They could have put that in.
And there is a default provision saying that when you do a redemption call and you put a redemption date and you don't pay up, that's a default, right?
They pay very little attention to Section 5B, which I would submit is the relevant language. They go to Section 5D. All 5D addresses is what happens upon a redemption. It does not address the antecedent question, which is the question before this court, is when is a redemption required? And it makes perfect sense. It says when there is in fact a redemption, the rights of the preferred shareholders are done. They turn over their certificates, the relationship with the company ends. It does not say anything about the circumstances that trigger redemption. That is found in Section 5B, and they really don't have any answer for the plain language in Section 5B, which has two requirements. There needs to be legally sufficient funds, and that the redemption has to be for all, not less than all, meaning if there's no legally sufficient funds to redeem all their
shares... Is there any dispute about the first issue, that the discoveries occurred, in fact, that there are no legally sufficient funds?
That was not disputed below. In fact, the motion court found that there was no dispute on that question. And this is not an example where Altisource was $1 short of a redemption. They missed the mark by $100 million. And that question, if it is disputed, and again here it's not, that's often a litigated question, right? That in these cases, if they think that the company is playing fast and loose with that determination, they can challenge it, just like you can challenge any board determination. That's not this case. There's no dispute that Altisource did not have legally available funds to effect a full redemption, and what they want, again, is a right...
Counsel, what do you mean by legally available funds?
That is a term in the contract.
Which means?
Which means that the funds to effect the redemption have to be out of surplus, and they can't render the company insolvent.
And so clearly they weren't going to render, if they paid out this redemption, the company would not have been insolvent.
Well, I don't think that's clear, Your Honor. The record shows they had $42 million at the time in net assets at the time this redemption request came in for $250 million. So that's why they never disputed down below.
You got BCL 513 protecting you there.
Right. Okay.
Thank you.
Okay.
Thank you.
Okay.
May it please the court. My name is Douglas Rappaport. With my colleague, Jackie Easties from Aiken Gump, we represent the cross-appellant appellees, Luxor Capital.
So your argument, the way
I'm just going to say, no one thinks this is ambiguous, right? You think the contract should be read the way that you think it should. The cross appellants think, no one says, we don't know, let's go to trial. So it's either one way or the other. Is that correct?
Your Honor, we cross-moved for summary judgment.
Right.
We are both here before
So
you.
everybody thinks, right. So we're not sending it back for a trial. It's either one way or another, correct?
That's correct, Your Honor. We
and the
defer
way
to
I
the
look, your argument is okay, we put in the redemption request, legally sufficient funds or legal available funds, all or nothing. They could pay us what they have and then owe us the rest. No?
Well, that's correct, Your Honor, and that's the application under New York law. They cited page 25.
But then you become, but that kind of scenario then takes this whole transaction turns this on its head then, doesn't it? If they do an IOU to you, you become creditors then.
Respectfully, Your Honor, that is not the case. First of all, let's turn our attention.
Wait a minute. What do you mean that's not the case? If you say that you pay us what you have and then owe us the rest, they basically, unless you correct me if I'm wrong, your shares have been redeemed. They've taken back your shares, and now you become creditors because they owe you money.
Your Honor, that accords with New York precedent, governing New York precedent here, because New York law governs this case.
New York law governs this case. I'm looking at the contract, right? I'm reading the contract, but what you're saying is something that I can't find in the contract where they have to give you an IOU.
Well, it's not an IOU, Your Honor.
But wouldn't that violate BCL 513? If we were to agree with your position, would we be essentially violating 513?
Absolutely not, Your Honor. We're asking you to apply BCL 513. As described in, let me just pull up one of my authorities here, the Lasora case, Your Honor, from 1984, Second Department. Court summed it up well. If the issuer fails to show redemption will render it insolvent, here's the quote. It is incumbent on the trial judge to award judgment to the plaintiffs even where the corporation, in ellipsis, is without surplus and is in fact insolvent. Moreover, in such circumstances, payments pursuant to the judgment would be limited to years in which a surplus is available. This is what we are requesting here, Your Honor.
But those contract provisions, that court, when it made that ruling, do they have the same contract provisions that we're dealing with here?
In what respect do you mean, Your Honor?
If I read it to you right now, this contract provision.
That you are entitled to partial payment, essentially. That's what you're asking.
That is not what we're arguing, Your Honor. We are entitled, in fact, to complete payment.
But they don't, it's undisputed that they can't make complete payment. So presumably, all they could pay you is
40 million. That's what he says.
If we take a look at Section 5D, Your Honor, Section 5D says, in the case of any redemption pursuant to this Section 5, unless the corporation defaults in the payment in full of the redemption price. Defaults, not fails, not misses, but defaults. In addition,
So then how do you deal with all or nothing? That's what it says. It says we redeem them all or we redeem none. That's pretty clear.
all but not less than all means exactly what it says, Your Honor.
Right. And we all agree they can't redeem all.
The redemption provision gives a holder the right to redeem all but not less than all of its shares.
No, all the redemption.
Well,
of
each
all
holder.
or none, right?
I
That's what it
didn't mean to cut you off, Your Honor. Each holder has the right to redeem all of their shares, but it obligates the company to honor the holder's request in full. It is a promise, not a condition. There is no conditional language as required under New York law with respect to
Okay,
this.
so let's say I buy the argument that they are required, once you ask for redemption, they've got to redeem it. But if they don't have the funds to do it, your answer is?
513A, Your Honor, as applied by the Rayburger case, as applied by the Nakano case, as described in the Lasora case.
Can't render them insolvent,
Absolutely not.
right?
They are obligated. The relief we are
So
seeking
can you point to anything in the record that would show that they wouldn't be insolvent if they follow through with what you're saying?
Well, Your Honor, if you take a look at cases like Rayburger,
You didn't answer my question.
They actually say the burden is on the defendant. But
You're both moving for summary judgment.
what I'm going to say here, Your Honor, is
I don't fall for that anymore.
yeah.
You both
What-
move for
what I'm
summary
gonna-
judgment.
What I'm going to say here, Your Honor, is crystal clear. Okay? The relief Luxor seeks here is in order finding AMC is default in its obligation to redeem Luxor's preferred stock for $144 million. If, as in Rayburger, as in Nakano, they do not have sufficient surplus under 513A to pay in completion, then the order that should be directed is that it must pay the funds it did have.
No, that can't even be because it says it has to be paid on the redemption date. You don't get, that's what the contract says. That's what you agree to. And if you don't get it paid then, you hold it for 5 years or you convert it to common, and then 5 years down the line on the redemption date, if they have the money, they redeem. It's not, it doesn't say the redemption date and every date thereafter that the company can come up with more cash. That is literally not what the document says.
Your Honor.
Before you answer that question, take some time to think about it. You'll get rebuttal time. Thank you.
Your Honors, it's exactly right that the relief they're seeking here would convert them from an equity holder into a creditor.
It's an IOU.
They could have purchased debt
Which is
with a
contrary to
guaranteed
this
right of
entire,
payment.
it's contrary to the entire transaction, right?
They chose not to. And, Your Honor, they do not cite if you look at their case.
Well, speaking of Nakano and speaking of Rayburger, those were not preferred stocks, right? Those were loans.
Those were not preferred stock cases, 1. 2, they did not interpret contractual language like the language we have at issue here. And 3, the redemption obligation was not challenged. In Nakano, the corporation had an option, a ROFO, to buy stock if it was offered. The corporation accepted the offer, thus triggering a mandatory obligation.
The counsel is pointing to the default provision of 5D. The way I read that is that that's if you actually agree to the redemption and you don't pay, that's default. In this case here, you said, we don't got the money to pay you.
Right. There was never a redemption issued, and that's the distinction. And I point Your Honor.
So wait a second, are you saying that the movements, the plaintiffs, I guess, here are remedyless?
Absolutely
like
not.
5 years from now, you don't have the money, 20 years from now, you don't have the money. So they don't get to redeem?
Absolutely not, Your Honor. They agreed to have 5 additional redemption dates in the
What
future.
if 2040 you keep saying, I don't have the money, I don't got the money, I don't, and you make, and you, your business model is to make sure you don't have the money on every redemption
In
date.
that instance,
So
Honor,
are they remedied?
They can, and I'm sure they will, challenge the board's determination that it did not have legally sufficient funds. They can challenge that.
Right now?
They did not make that challenge here because it was not disputed that the company was not even close to effecting a full redemption. Section 5D presupposes that there's a redemption obligation. And I would point, Your Honor, to the trading stream case.
Wait a second, what kind of claim could they make against their shareholders, right?
The board has a duty of good faith.
Okay,
when it
so
is
you're
making
saying that they could make a breach of fiduciary duty claim against the board for failing to, I guess, effectuate the contract in good faith?
If they believe that the board's decision was not made in good faith, if they believe that the board took steps
Isn't
to
that a really
avoid a
high
redemption.
kind of thing?
Your Honor, that's
Under the business judgment rule, we're never getting to that,
If
right?
you look at the ThoughtWorks and trading stream cases, which are directly on point here because they find that a redemption obligation is not mandatory, that's exactly what was challenged and then went to trial. Was the board's determination justified? They can challenge that. Again, that's not this case. There's no dispute down below that Altisource did not have legally available funds to effect a full redemption. I would submit that under the plain language of the contract and basic canons of contract construction, as this court knows, the Court of Appeals has been adamant that a contract between sophisticated parties means what it says, and it is not the role of the court to imply or add a term that these sophisticated hedge funds could have negotiated for, but they did not. And in fact, in other cases, and we put this in our reply brief, they negotiated for the exact right they're asking this court to impose here.
Thank you.
Thank you.
If I may, Your Honor, I just want to speak to this concept of remedyless.
I just want to make sure, I think you are not remedyless.
Oh, I believe I am, Your Honor.
Well, why don't, if you thought that this was inappropriate or that the board of directors was fudging the books and they really did have the money, why didn't you sue for breach of the covenant and good faith and fair dealing or breach of fiduciary duty?
When you say remedyless, Your Honor, first of all, there were reasons that
I just want to, let me ask you,
let me
before we even start, let me just ask you, you're not disputing they didn't have the cash. So this time you could not have sued
based
them.
on the information that we have, Your Honor,
Okay,
we
but
believe the
okay.
company had $42 million.
Right, so this time you don't have that. And then 5 years from now you may have it. In between, you can always convert your shares to common shares, correct?
At some point in the future, yes, although the shares, that made economically no sense. But let me point Your Honor to something that Your Honor said with respect to remedy lists. The appellants here have said flat out and emphasized in their reply brief that, quote, their position is clear that, quote, if AMC lacks legally available funds to redeem all but not less than all of the outstanding shares, it has no obligation to redeem on the mandatory redemption date. If you take a look at 5B, 5B is riddled with mandatory language, okay? It says, 5B, the opening, at its option, each holder shall have the right in its sole discretion to require the company to redeem. So
Yeah, there's no question about what you as shareholders can compel the company to do, but the backstop for the company, from what I'm reading, is that if they don't have the money, then that's it. You can't get trying to draw water from a rock.
Yeah, so well, if they don't have all the money, then they are held in default. And by the way,
The provision doesn't say that.
The provision doesn't say that.
well, Your Honor,
You got two of us already coming at you on that one.
The language that we're pointing to is that the language in the contract does not create a condition precedent. We have compulsory language in 5B saying.
We're not looking at condition precedents. We're talking about a situation where I'm telling the company, I'm redeeming my shares. You got to buy back my shares. Company says, I don't got the cash to buy back your shares right now.
Right.
And then you're saying, well, you know what? Buy back what you can and owe me the money later on.
And you know that
Where does it say
that
that?
accords with governing New York law under 513.
Yeah, you know what? You say that a lot, but all those cases, we've read the cases, they don't deal with the same kind of provisions we're dealing with here.
Yeah. Well, let me explain one case that does.
You didn't tell me that I'm wrong.
Well, Your Honor, respectfully, we
I don't
think-
ask the question I
we
don't know
thi-
the answer
believe
to.
We believe the analogy holds true regardless.
The analogy holds true, but I'm talking about contract provisions.
But let's talk about this case. They've cited to ThoughtWorks and they cited to Trading Screen. Respectfully, those cases are not on point here. The case that is on point is QC Holdings. In the QC Holdings case under Delaware law, which, by the way, does not govern this case, but nevertheless, that's the one case the parties found in which an issuer made an argument like this. And in QC Holdings, the court reviewed this argument, this one day only, the one day only, all or nothing argument, and the court rejected that argument.
Okay.
The court found flat out that that argument was absurd
We got it.
and commercially irrational.
Thank you, Counselor. Thank you both. Thank you for the good argument. It's good. Thank you. Heba versus Corey Robbie.
Good afternoon, Your Honors. My name is Brian First from the Center for Appellate Litigation, and I represent Mr. Corey Roby. I'll be focusing primarily on the CRY issue today. People were required to prove by clear and convincing evidence that Mr. Roby's actions actually caused the complainant, Katie Guerrero, not to testify. So if Guerrero had decided prior to speaking with Mr. Roby that she was not going to testify, then he could not legally have caused her unavailability. And that's exactly what the record shows here. And I'd just like to point out that even if there was some ambiguity here, even if, well, likely she wasn't going to testify, maybe she was going to testify, maybe she wasn't, that ambiguity must be resolved in favor.
It's a clear and convincing evidence standard.
Yes, Your Honor. Yes. And so
what do you think he meant when he called her, even though there was an order of protection in her favor prohibiting him from doing so? What do you think he meant when he called his father, Mr. Dennis, and who said he was going to see Guerrero to convey a message, do not come in to the Grand? What do you think that meant?
I think we all know what that means, Your Honor, but my point
So
here...
he said to her, do not come in and testify against me, correct?
Correct, Your Honor.
And that at that time, she had not said one way or another whether she was going to, for sure, testify or not, correct?
And there I disagree, Your Honor.
What did she say?
Well, because that conversation took place on July 16th.
Right.
Right? And on July 2nd, the day of the incident, that is the day that she said she made up her mind of what she was going to do.
She didn't say what she was going to do. She said she made up her mind.
No, she said, okay, but if you actually, okay, he asked her, have you made up your mind of what you're going to do?
Again,
She says-
he's asking her, there's an order of protection, and he's continuously calling her. Are you gonna go to court against me? Are you gonna go to court against me? I am the father of your child. I don't want to spend the rest of my life in jail, right? He's continuously calling her. When he calls her and he says, what are you gonna do? And she says, I've made up my mind. She doesn't say, I'm not coming in, correct?
She says, I've made up my mind and I forgive you.
I forgive you.
And I forgive
that
you.
could mean
No,
anything,
and then
correct?
and then he asks, no, it can't mean anything. If you actually look at the context here of what this means, and then he asks her again, and he says, you haven't, so what are you going to do? She says, I already.
Well, if he knew that what she was going to do, why do you think he asked her again?
I'm not saying that he knew, but his subjective.
If you're saying clearly when she tells him I forgive you, that means she's not going to testify, why would he have to ask her again? Why would he have to call her again?
It's very different.
Why would he have to continuously call her?
First of all, to this point about continuously calling her, Your Honor, the only reason there's continuous calls on July 17th is because he was poor and he had no money in his account at Rikers, so he was forced to make calls in 6-minute increments. So I just want to put that aside because the people and the court below made a lot of that, and that's inappropriate to hold his indigency against him in this case. But to this question, I understand that it seems his intent was to make her not testify. But if you look at the record,
I mean, he literally said it. It wasn't unclear.
Right.
He said to her, tell her do not come in to the Grand.
right, but at that point, she had already decided that she was not going to testify.
What evidence shows that? The fact that she said I forgave him?
No, she says that we know she made a decision on that day, and the people say, well, we don't know. She could have been wanting to testify, she could have not been wanting to testify. But it doesn't make sense to say, I made up my mind, I forgive you, and then he asked her just a little bit later, he says, so what are you going to do? And she says, I just told you I forgave you. Shouldn't that be enough
This
said?
was all played out before the jury? These recordings?
Well,
No?
we're talking about the Sirois decision, which that was just in a hearing. So that was the Sirois decision.
Okay.
Okay, but what does that mean? Shouldn't
But
that
if
be
you're
enough
saying
said?
that, my notes indicate that on the 5th of July, the investigator speaks to her and she's not eager to testify. So that doesn't suggest to me that she had really made up her mind as of that time. And it's really, when I looked, it was on the 22nd when the investigator goes to serve a subpoena, where it's clear at that point she's not going to testify.
The DA investigator specifically said that she didn't ask her if she was going to testify straight out, but she said it was her impression that at that time that she did not want to testify. So if we know that she's made up her mind on July 2nd, that she... Go ahead, sorry, Your Honor.
I apologize, go ahead.
I was just saying that if we know that she's made up her mind on July 2nd as to what she's going to do, and every single person in law enforcement and the DA that comes across her thinks that she doesn't want to cooperate, it's clear what her decision was. But I think the most clear...
If it was so clear, why does he ask her again? I mean, you're saying I forgive you means I'm not going to testify against you. Except clearly he didn't think that because he asked her again and he called her again. And he called her again.
But the second time she says, I forgive you, shouldn't that be enough said? That's unequivocal. Shouldn't that be enough said? We all know what enough said means. It means you don't need any more information to answer your question because the information I've given you is sufficient. That's the only thing that could mean. And we're talking about a situation...
Why couldn't it mean, I don't know yet, because she doesn't really say one way or the other. I mean...
Or I don't want to be badgered by you anymore. I forgive you. Leave me be.
Well, hold your thought.
Okay,
You got
sorry.
rebuttal time.
Thank you.
Good afternoon, and may it please the court. Molly Morgan on behalf of respondent. The victim had not decided whether or not to testify on the date of the attack.
Why? So counsel says when she says to him, I love you, that means I'm not going to testify. Why do you dispute that that's what that means?
I don't think that concretely means that she wasn't going to testify.
Or I'm sorry, not I love you, I forgive you, right? It's not I'm not going to testify, but why shouldn't we assume that that's what it means?
It just doesn't make any sense in light of all the other evidence. First, her cooperation with law enforcement, while she was a little bit maybe reluctant to speak with them. She had just gone through a very traumatic event, and she nevertheless told 2 police officers on the day of the attack what happened. She gave a detailed account. Then an investigator came to speak with her, and the investigator told her, basically, I'm going to come back tomorrow with an assistant district attorney to speak to you, but please give me a call if you want to cancel. She didn't call to cancel, and in fact, she sat down for a detailed interview with that assistant district attorney. And then I'd also note that an investigator noted, although it didn't seem like she wanted to testify, the investigator clearly testified that she didn't say she wouldn't testify, and in fact, she seemed slightly more cooperative on that second day than she had the day before.
Could her behavior be explained in terms of her being a victim of domestic violence?
Yes, absolutely, and that's how the trial court interpreted all this evidence, which is of course critical, to the victim's actions and reactions to defendant. Of course, their relationship was beset with domestic violence. There was escalating violence. There was an incident where he pushed her down the stairs and broke her hand.
There was testimony from the social worker Slesar too, as well, right? So there was some expert testimony concerning the behavior of victims of domestic violence.
Exactly right. And as the trial court did note that domestic abusers can use more subtle tactics in order to manipulate victims. It's not always going to be direct violence or threats. It's not going to always be if you testify, I'm going to come after you. Sometimes it's those subtle messages, and of course,
Which were in the 7 calls that he made.
exactly, yes. He used kind of a cornucopia of tactics. He started off with the apologies and the love, and I'm so sorry for what happened. But then when she said that's done, his tone did get harsher, and then he started playing on her guilt, repeatedly saying that he was facing life, bringing in their mutual child, which of course the expert witness testified that domestic abusers can use a mutual child in order to further manipulate the victim. He said, what am I going to tell her when she asks why I'm in prison? Oh, quote, mommy put me here. It's just blatant manipulation, and of course, as Your Honor pointed out, it's far from clear that defendant believes she wasn't going to testify. I'd note that just one day before the grand jury's subpoena was served on the victim, defendant said on the phone to his stepfather, I don't know what she's going to do. And then his stepfather said, oh, well, I spoke to her. She said she wasn't going to press charges, which just goes to show the level of manipulation that was going on behind the scenes beyond the recorded calls that we do have. And also, I would note that, while my adversary would make out their calls as lovey-dovey and normal couple stuff, on July 19th, he called the victim and he asked her again what it was she wanted to do. And she said, quote, whatever it is I want to do. That's July 19th. She's still saying, I'm going to do what I want to do. And the trial court correctly interpreted these quotes of forgiveness from the victim as her being circumspect. It makes sense. She had just gone through a horrific attack where she was stabbed through the hand, stabbed other places, her kneecap was broken, horrific stuff, and yet she also was still in love with the defendant. She had a young child with the defendant. So it's, again, a very complicated set of emotions, and it's not going to be a straightforward yes or no. I would also just like to point out that any reluctance by the victim isn't dispositive. The defendant's misconduct simply must be a cause of the victim's unavailability, pointing to our brief at pages 51 to 52. And this makes sense as witness tampering is inherently surreptitious. Courts have recognized that a defendant
It's
isn't...
never direct. It's never direct that you can see it right off spotter right away.
Exactly, yeah, and a victim is not going to say, I decided to testify because of what you're saying to me. It's just not the way it works. So again, I would also just note that, his manipulation was not only, laid bare in the way he treated the victim, but also the way he talked about her behind her back, if I might just finish. He said her broken kneecap would heal, and that he had been telling her bye, but no, and that he would rather lose out on everything and come home and not have to deal with her.
Thank you.
We request that you affirm. Thank you.
So, briefly, Your Honors, this idea that Mr. Roby's subjective belief about what she was going to do should be controlling it. If he didn't know, then how could we know? But it's very different than a man with bipolar disorder.
It's not a subjective belief because she is equivocal about it. So how does domestic violence play into her thought process?
I think
there is scientific basis in terms of that relationship. Isn't that what's occurring here?
No, I think that this case was shoehorned into a DV case where you have the only.
This is not a DV case?
The only, I mean, the incident.
I'm sorry, this is not a DV case?
But I'm talking about, we're talking about cycles of violence and history of violence, and the only prior domestic incident that was introduced was an argument that was yelling, that was never
She wasn't
violent.
pushed down the stairs?
That was a conversation that she had with him on the phone, and so she also said that nothing had ever happened between the two of them. And so I think that the critical point here is that even if this is a DV situation, even if he had intimidated her, which he did not, he's mostly just asking her if she's going to testify. The key question is, did she decide before he spoke to her? And I disagree with that she was equivocating or that it was just expressing reluctance. Everything she said, if you just look at the totality of it, when she's saying, I made a decision, we know from the beginning she's made a decision.
Yet she doesn't say what the decision is.
She in so many words, she does, though. When she says.
See, what I'm hearing here is that, you're saying that this is what the defendant is saying. This is clearly his intentions. And we don't, you're saying that this is the Guerrero's intentions too. But, as I'm listening to the arguments, it's really still kind of flows back and forth. I don't get a clear indication from her in the recording saying, fine, I'm not going to testify. Fine, I've always decided, I've always never thought I was going to testify, and I won't go testify. I don't think she ever says that.
But she doesn't say that in those direct words, but we don't have to turn off reason. If we look at all the things that she said, it's clear that she wasn't going to testify. That's what I'm saying, is that if she's saying, when she says that should be enough said, that is, as we just discussed, that can only mean that she's decided not to testify. She's answering his question. It doesn't make sense to say that should be enough said, I'm going to testify against you. Okay. This is a recorded line. She knows that she's going to talk about violating.
And your argument is that all that defendant said to her didn't procure her unavailability at trial? Him telling her that he would have to tell their child that he was going to go away for life, and all of the things that he said to her was not the procuring cause?
No, if she decided beforehand, then it just logically and legally cannot have caused her unavailability.
If she decided beforehand, why did he call her on July 7th, 16th, 17th, and 19th?
Well, because he's incarcerated. He's not.
And there's an order of protection again that he knows about, right? And yet he's still calling her and I'm not saying, yes, he called her several times, but he called her on 3 separate days, still asking her, are you going to testify against me? And all this other conversation about, I'm going to have to tell our child that I'm going away for life. And you're saying that was not, that by the time that he called her on the 17th and the 19th, she had already decided not to testify.
I think that looking at this at a clear and convincing evidence standard, we have to take her at her word when she says.
No, but what I am saying to you is then how do you explain the defendant continually calling her if she had said to him, I am not going to testify?
Because, like I said before, Mr. Roby's subjective belief about what's going on. This is a man with bipolar disorder.
I'm talking about us looking at it objectively.
No.
If I know that someone's not going to testify against me, I know that I have an order of protection that requires me not to call them, and yet I'm still doing that. Objectively, that's evidence that he coerced her not to testify, correct?
No, not if she had already decided not to testify. And so what I'm saying about his subjective belief, all I'm saying is that us looking at this record here can determine that she had already made up her mind, and Mr. Roby, who is suffering from bipolar disorder, clearly panicking, extremely anxious, is making these phone calls, and he's not thinking straight. So I'm just saying, just because Mr. Roby wasn't convinced and she's not going to testify, it doesn't mean that objectively looking at the record that that's not true.
Okay, thank you very much.
Thank you very much.
Andela versus 345 West 70th Tennis Court.
Good afternoon, Your Honors. I'm Charlotte Bickman, appearing for the appellant. Paul Fiandella. The court below granted pre-answer dismissal of a plaintiff's breach of warranty of habitability and retaliation claims.
Let's talk about your retaliation claim. What's the basis of the retaliation claim?
There are several actions in retaliation for plaintiffs' complaints regarding the conditions. It started in October 4, 2019, when they issued a notice to cure, which specifically states one of the grounds for that notice to cure is that he opposed defendant's motion in housing court for access to complete the repairs without actually addressing any of the structural issues. At that time, they had no DOB permits. Housing court judge denied that motion. So the October 4th notice to cure states that they intended to terminate his lease, which would allow them also to seize his shares.
So is the basis the stipulation where?
Well, there's three actions that could constitute retaliation.
So in other words, although your client agreed to essentially sell the place and vacate, which occurred as I understand now, you still believe that you can go back to actions that occurred prior to the time of stipulation to say there was retaliation? I mean, isn't the basis really it concerns the notice to cure dealing with the electric box? That's really the issue here. Wasn't that the basis of the retaliation claim?
Well, there are two things. Initially, plaintiff had to go into court because the notice to cure with regard to whatever it was, because it was a very vague notice, but arising from the inadequate electric service.
It's pretty specific. Well, I mean, I don't mean to interrupt you, but it's pretty specific. It talks about the box and the electrical problems that were raised by your client.
No, what is confusing about it is that the unsupported wall was unsupported because the defendant's president has cut the wood vertical supports in the north living room wall.
I guess what I'm trying to understand is why is that notice to cure, when you make your client makes a complaint, notice to cure is served for access, et cetera, why is that retaliation? Why is there retaliation when the notice is served based on your complaints and they want to take a look and deal with it? Why is that retaliation?
Are you going back to the 2019?
No, I'm talking about the last notice to cure before you brought this lawsuit.
Okay. Well, no, the defendant's papers state that the notice to cure is a predicate notice for termination. You have the.
Well, what does it matter? You have a stipulation. Termination is over. You're leaving in however many months.
Oh, but the stipulation reinstated the lease and says very specifically, and following, I believe it's paragraph 12, states that the parties have all the obligations under the lease. So obviously, the defendant believed that they could evict Mr. Fiandella without ever doing anything that was repairs that were required under the stipulation. If you look at the notice to cure and the emails from defendant's counsel, which invokes 31F, which is sort of what's known as the Pullman action, the paragraph that allows a board to simply vote to terminate a lease based upon their conclusion that the conduct is objectionable. And the papers state that Mr. Fiandella made complaints to the co-op, called in HPD, and that was the basis for its actions, its predicate notice to cure, which was really just a sham because for its intent to terminate the lease. So clearly, they believed they could terminate and evict.
Didn't you have a stipulation in 2020 releasing everything that happened prior to 2020, correct?
There is a stipulation.
And the stipulation releases all the claims.
But the problem is that they didn't perform under the stipulation.
But you didn't sue for breach of the stipulation, did you?
Plaintiff sued.
You sued for retaliation, correct?
And
breach of warranty.
Breach of the warranty of habitability. And the third cause of action was for an order to enforce Mr. Fiandel's rights under the lease, to have them actually do the repairs, which they did not have a
Okay, but at this
contract
point,
to
your
do the
client is out,
repairs.
correct? Your client is,
He sold the shares, yes.
So what's left in the action? It's really a damage
Damages.
action for breach of warranty of habitability.
Well, damages for breach of warranty of habitability and for retaliation.
But you can't, you signed a stipulation giving up that
Well,
claim.
the stipulation, as noted in my papers, the statute also prohibits agreements which substantially alter the terms of the tenancy, or I should say actually actions by the landlord which substantially alter the terms of the tenancy. And the stipulation
Did you
does
raise
not
that
prove
below?
a non-retaliatory motive.
Did you raise that below?
In the opposition papers, I cited, first of the complaint cites the entire retaliation statute. The opposition papers actually do identify that the statute also includes substantial alteration of the agreement. Also, the posture of this case is pre-answer dismissal under CPLR 3211. And the defendant's argument, which the court below erroneously accepted, was that the stipulation was documentary evidence. Under the CPLR, the documentary evidence has to irrefutably establish a defense as a matter of law and resolve all factual issues. Well, the stipulation doesn't establish a non-retaliatory defense. It does the opposite, because if you look at the stipulation, it says, as a condition of having the repairs made, you have to vacate your apartment. And that's precisely what the retaliation statute addresses, because the legislature recognized, after it established the warranty of habitability statute, the landlords would retaliate and either modify the lease or
vacate the
evict.
stipulation? I mean, isn't that your remedy? That if you're essentially saying that the stipulation violates public policy, that's what I'm hearing based on the amended statute, don't you have to move to vacate that?
Well,
And before you answer that question, you have time to think about it. You have rebuttal time. Thank you.
Thank you.
Good afternoon, Your Honors. Daniel H. Richland, Falkowski PLC for the respondents. I think Your Honors are completely correct here.
Okay, sir, but let's just talk about the warranty of habitability.
Please.
Why doesn't the tenant here have a viable claim?
Sure.
That she should be able to establish through discovery for breach of warranty of habitability, essentially from the time of the stip to when the tenant vacated?
Great question. There's two answers to that. The first answer is that the idea of the stipulation was a final resolution of claims between the parties.
Did the stipulation have language like that, saying that it's resolving all claims with respect to breach of warranty of habitability, and how could it give up future claims?
Sure. Excellent two questions there. So the stipulation resolves Fiandella 2, which was an HP action where the warranty of habitability had been raised. And the stipulation further provided that once this work was completed and they vacated and they left, that at that time we would get a general release, right? So the general release should, in effect, resolve all
They
these
weren't
claims.
executed. General releases weren't executed,
That's correct.
right? So you have no release for future things from the date of the earth to the date of ever. All you have is the release of claims up to the date of the stipulation, right?
Right now.
And did you prove, so that, again, this is a pre-answer motion to dismiss. Maybe you did repair everything, but we couldn't possibly know that now. So how could you say that you can't, that the tenant can't even claim breach of the warranty post stipulation to the time that the place was vacated?
That's a great question. The answer to that is, in general, when you're executing a stipulation that's prospective with respect to work that's...
Where does it say it's prospective?
Well, the work to be performed is
Yeah,
prospective.
and what happens if it's not performed?
Well, what I would say to you is that in that case, it is possible that there could be a breach of the warranty.
So how would we know until there's an answer and discovery?
Well,
the claim has been made. Maybe you did do it all. Maybe you complied with the stipulation. There's not a general release. There's a stipulation that gives you a buy up until the date of the stipulation. So how can we dismiss that pre-answer?
Well, the fact that has changed in between, of course, is the sale. And the problem with the sale is that that changes whose rights are now affected by the stipulation with respect to the work. I appreciate that there's a factual dispute over whether the work was completed, but the person who would now be able to say the work is completed is the new owner of the unit. So to the extent you're
Yeah, but
remanding
how
it,
does that affect the legitimacy of the claim? It only affects how you're going to prove it or not prove it. It's whether or not, were I pre-answer motion to dismiss, has the plaintiff stated a claim for post-stipulation breach of warranty of habitability?
right. And the court below correctly held that they did not because they did not prove the extensiveness and the character of the harm flowing from the violation.
Do you have to plead that, and do you have to put that in the pleading?
According to the case law, yes, because the case law says
Because I've read it a little bit differently.
that is the plaintiff's position. My position would be that you do, in fact, have to plead those at least.
And
with
well,
some
if
degree of
I plead there's a Class B violation, doesn't that at least get me over that hump? There's a prima facie there?
According to Mitchell, you have to have a substantial violation, substantial being something that
Class B is exact, I mean, I can, right?
Just refresh
Class
my
B?
recollection, what is a Class B violation
I
again?
believe it has to be cured within 30 days.
Oh, so it's a hazardous condition?
Oh, yeah, of course. Yeah.
So if that's pled, doesn't that make out the prima facie of warranty of habitability?
I think it would depend on the exact conditions contained in the violation and specifically whether or not they pled the remaining factual factors. I think the whole point is that that's a factual argument you actually have to plead some facts on. Like, for example, in the Joby case, you had a situation where they're involving rats, right?
Well, like
an
my
infestation.
colleagues say, it's a 3211. You're at the pre-answer stage. I mean, so you just barring just taking from what you're saying is like we need to. I mean, is there enough bare minimum allegations in it to get it over the hurdle? And
Right.
it sounds like you're not resisting too much. But,
Well, I think if you're asking as a matter of philosophy, I tend to think that the courts kind of have to create a rule here, or at least examine the prior case law that's been promulgated. And
Okay, so Joby says you have to just state it enough. There is a Class B violation here, which is a violation defined as hazardous to life, health, and safety, which is exactly what the breach of warranty of habitability claim at the end of the day would have to prove. But once I plead those two things, what else are you saying you have to plead?
Sure. I'm not sure that Class B by itself would necessarily satisfy a breach of the warranty of habitability because, again, it would depend on the specific nature of the facts.
But this is a pleadings motion. Maybe on summary judgment, you're correct. I don't know. We don't know what the record is, so it's hard to say.
I think actually that's part of my point. Below, I was not arguing for a 3211A7 dismissal per se. I had a 3211A1 based off the stipulation. And the idea behind, for me, on the stipulation was that that was supposed to resolve it, that once we completed the work, that any claims regarding the breach of the warranty of habitability were subsumed within the stipulation itself.
Yeah, but that goes back to what my colleagues were
Right.
saying, that it was an ongoing process that you had to go do the repair work, and then you had documentary evidence that says, okay, here's the bill, here's the contractor signing off on everything, everything's done.
Right.
That's
Right.
it.
I understand. So to the extent that that was not available at the time and based on what these motions were based on, given the nature of the time flow of the CPLR, right? If we were to make that motion today, it would look a bit different because the facts have changed on the ground. What I would just say is that when you're considering what the pleading standard for a breach of the warranty of habitability should be, it should match what Mitchell says is the requisite factors, which is you need to plead a substantial violation, and that substantial violation has affected the health, the tenancy, and its usage.
Thank you.
Thank you. I have one final point here, and I apologize. It's with respect to the retaliatory eviction. I think there's really no dispute that the allegations made in the complaint did not satisfy, and it can't make that claim, here. Thank you.
Thank you.
With regard to the warranty of habitability, the DOB violation states that the structural damage that was caused by apartment 2A's renovation, it states that the vertical wood supports for plaintiff's walls.
And did you allege in your complaint, in fact, that the repairs weren't made pursuant to the stipulation? Did you allege in your complaint that the repairs weren't made pursuant to the stipulation?
Yes, paragraph third cause of action requests an order for the court to to issue a permanent injunction requiring them to make repairs that, because their own engineer had ultimately, after the stipulations was signed, admitted that there were structural...
That's all moot now. Your client's out. All you're asking for money damages.
We're asking for damages for the over 4 years and 3 lawsuits.
Over what?
Excuse me, it took over 4 years.
No, the only claim you would have, if you have a claim, would be from the time of the stipulation to the time that your client...
Well, I would suggest that my papers state that paragraph 2 of the warranty of habitability statute says that agreements to waive rights under the statute are void as a matter of public policy.
So move to vacate the stipulation.
Yeah, that, I was going to ask if, to follow up the question is, why didn't you move to vacate the stipulation? That was the last question that was posed to you.
Does that apply to tenancies in cooperative buildings?
The warranty of habitability statute applies to all residential buildings. Co-ops don't get a free pass, and I cite cases. As a matter of fact, defendant cites the Littman case, in which, and doesn't support his position, because in that case, the stipulation provided for a 50% rent abatement, and I think it's $16,000 in additional damages. This stipulation waives those rights to the rent abatement and the damages. I think that this legislature anticipated all the ways in which landlords would try to manipulate the tenants and retaliate against them. And the purpose of the statute was actually to incentivize tenants, and that includes the lessees in co-ops. And we know from the condominium collapse in Surfside, Florida, and more recently in New York City, you have a garage collapse. But in Surfside, Florida, they simply didn't want to spend money to make repairs. And here, Mr. Fiandella from August of 2017 said that there were structural problems. And my reply papers show how they repeatedly lied in the housing court and claimed there was no structural problem.
Counselor, you have settled those claims. You entered into a stipulation.
Well, he never argued in his motion to dismiss. He never argued res judicata or anything with respect to that, and waived that defense if that's what the court
All right.
suggested.
Thank you very much. We have everything. Thank you. 215 West 84th versus Bailey.
May it please the court, my name is Jeffrey Metz. I represent Adam Bailey and our law firm. I'm here this afternoon, Your Honors, asking you to modify the order of the trial court to grant the defendants legal costs, legal fees and costs, as well as punitive damages under the anti-SLAPP statute.
So does plaintiff's action involve public petition and participation?
It absolutely does, Your Honor. And as a matter of fact, I think Judge Krause's opinion was well-reasoned, except when she got to the SLAPP, because she really relied on the outdated statute, not the statute that applies. Under 76A, an action involving public petition and participation is a communication in an open place, open to the public, or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech, et cetera, et cetera. Public interest is defined under the statute to be broadly construed and to be any subject other than a purely private matter. Now, this is not a purely private matter. If you look at the history here, there was a holdover proceeding that was brought. Our client files an ERAP application. It affects an automatic stay. Landlord was not happy with it.
What happened? Did your client get those funds?
The client was eventually turned down for the funds. However, at the time that this was pending, there was a motion made by the other side to vacate the stay, and that was denied because the housing court said that there was a colorable claim. So the landlord was stymied there. Now, the landlord did not take that up with the state that passed the emergency legislation. What the landlord did was, one, sue Mr. Azu for $85 million in a plenary action, in and of itself an extraordinary event. Also, very classic landlord harassing behavior, the mind-numbing noise right outside, the keyhole camera across, the debris falling down, the limited access, the elevators breaking down, and then when we get hired to represent Azu in the summary proceeding and in the plenary action, shortly thereafter, we're sued. Now, I don't know of any case where an attorney representing a client gets sued for that, and on the basis of an absolutely frivolous case. Abusive process was dismissed as a matter of law. Tortious interference with prospective economic interests, dismissed as a matter of law. Now, when we made our motion to dismiss, if there was some problem with their complaint, well, we know you can submit an affidavit to try and bolster up. They didn't do that. Instead, they completely pivoted to this absolutely phony claim that we told Azu to file the ERAP application. I can point
Didn't you file the ERAP before he retained you?
Yes, that's correct, Your Honor. 5 weeks before we were retained. So Azu said he submitted an affidavit. He said he did it himself. The landlord was aware of that because Azu submitted an affidavit in support of our motion to dismiss. Yet, landlord lied to the court below and said that we told him to do so. And
well, hang on a second. And in fact, even if retained counsel were to give that, were to tell that to the client, that's part of the attorney-client relationship, right? I mean, it's advocacy in that sense, right?
Absolutely, Judge. Judge Krause said that even if we had advised him to do that, there's nothing untoward with that behavior.
I just want you to focus on why this isn't just a landlord-tenant dispute between
very
the
easy.
two, right?
It's easy because this case raises an important public policy issue, Your Honor. Attorneys have to be free to represent their clients zealously, free from knowing that they are going to get sued precisely because they're representing their clients. On the other, correspondingly, the client has to know that the attorney is not going to have a divided interest. Now, here we have a situation where, even though it was frivolous, until it's dismissed, it's still alive, and we're potentially subject to $25 million in liability. Now, we decided we're going to go full bore with this case because we thought that there was no merit to what was going on. So you've got this, look, when we go to law school, the first thing they teach you in law school is that you zealously represent your client. That's what we were doing, zealously representing our client. That is not actionable conduct. And if
You know, the bottom line is if we were to disagree with Supreme Court, that would be setting a new precedent in the sense that lawyers no longer have to worry about getting sued by their clients for legal malpractice. Now you're going to have to worry about being sued by the other side suing you for doing something that you shouldn't have done. So now you, as an attorney, you're going to have to call your legal malpractice carrier and say, oh, by the way, we now have a situation where I might get sued by somebody else now that I didn't represent.
Judge, look, you know, it's really, come on.
It's a can of worms that we're opening up.
Let's be straight about what happened here. This was all an intimidation tactic right from the get-go. As soon as the stay was in effect, he gets sued for $85 million. Then they sue us for an additional $25 million, all for one reason.
I'm looking at the big picture. I'm looking at the big picture in the sense that this loss, the record here indicates to me it's like this is really not a place where attorneys need to be in terms of having a concern in terms of representing clients. But you know, did you have a question, Counsel? Okay, thank you, Mr. Metz.
Thank you.
Good afternoon, Your Honors. May it please the Court, Y. David Scharf of Morrison Cohn for the respondent. Justice Krause actually got it right.
Oh, okay, but would you agree that it was the old statute she used?
It was, but...
Well, let's talk about the new statute.
Yes, so both the new statute and the old statute and this Court's decision in Miller and Aristocrat say that we need to, in the first instance, have a matter that is of public petition or participation. And the analysis is not our complaint that we filed in court. The analysis is what was underlying, what was the conduct that we were complaining of. And there's this notion that we made a pivot. And I think it's important for us to recognize that there was absolutely no pivot whatsoever, because the two issues that we complained about was the filing of an ERAP petition, which is a private matter. The second thing was...
So you didn't accuse Bailey of a media smear campaign to get a large buyout, et cetera?
Yes, but if you...
So let's focus on that part.
But
as an attorney, you think it's appropriate for the other side to sue the adversary because they're advising a tenant, whether it's misconceived or not, to hold out for a large buyout?
A lawyer is not immune from what every other person is out there. If somebody else is liable...
No, you cannot say a lawyer is any other person. Lawyers have a special place in terms of the legal community, right? And what really pushes me here is that you did not cross appeal from Supreme Court's dismissal of your two causes of action.
Yeah,
that's very telling in a sense that why didn't you, I mean, that to me would say that, no, we had meritorious claims and we're going to press it on appeal.
Your Honor,
cross appeal from
sometimes people can let it go and sometimes people can't let it go.
Yeah, okay, letting go is fine, but counsel, the way I look at it is, and you heard me, I'm more concerned about the bigger picture, because now we're having a situation that's not only attorney. If we were to agree with you, we'd be opening up a new, I think, dimension in terms of attorney liability. It's no longer that they're going to get sued by their own clients for legal malpractice, but they have to also worry about the adversary suing them, saying that, you know, we don't believe what you did was proper. That's kind of...
Your Honor...
is that where we're going to head down if we were to...
Well, Your Honor is suggesting that lawyers get a free pass on and that there is no conduct that they can engage in that can't be tortious towards the opposing...
Okay.
Wow, that is not even close to what we are saying.
Yeah.
What we are saying
Thank you.
is that I am sure you have taken aggressive stance. In fact, I know for a fact that you have, because
Don't
you have
hold that
appeared
against me,
before
Your
me
Oh, no,
many,
both sides.
many times. You have taken aggressive stances on behalf of your client.
Never over the line, Judge.
There's no over the
I've
line.
never
Your claim was
I've
dismissed.
never stood in an advertisement, okay, with my book. Not that I've written a book, and had my...
Some of your briefs are Brooks, though, but okay.
Your claims were dismissed. Your
correct.
claim that that Bailey commenced a smear campaign, that was your whole tortious
but that's where you're
interference
wrong, Your
claim.
Honor, if I
That is
may.
not, that is a matter of public discussion and debate. Whether an attorney can zealously represent their client in real estate in New York City, which, as we all know, takes up a lot of airtime, a lot of
Hot topic.
news time, right?
Can we just look at the complaint, Your Honor, please? Because this really goes to the heart of it. Let's look at both causes of action. First cause of action, record page 29, abusive process, paragraph 50, which is first...
What process was issued?
I'm sorry?
What process was issued?
Yes.
What process?
Used judicial and administrative process of the state of New York, ERAP.
No, but the client said, he puts an affidavit in saying that the client himself put ERAP in before the representation.
Your Honor, but let's go back, okay? Because they put in an affidavit, but if we look at the time of the pleading, paragraph 31
I'm sorry, Mr. Scharf. I'm not buying that argument that application was processed in the sense of how we understand an abusive process claim in this state.
Your Honor,
Have you never told your client to take an aggressive notice to cure stance in a case that it was later dismissed as unwarranted? Of course you have.
Your Honor,
of course you have. And so this lawyer telling his client to file for a government benefit that you don't think he deserves doesn't rise to abusive
that
process.
he's not entitled to, that
That he
everyone knows he's not entitled to, that every lawyer should know it's not an
So
entitlement.
every time your notice to cure is dismissed, that means that you're not entitled. You're not entitled. You're not entitled. Correct?
But that doesn't make the underlying frivolous. That doesn't make the fact that in the tortious interference claim was predicated...
Where was the evidence that the tenant interfered with the developer's contract rights to build the skyscraper that they claim this holdout tenant.
We're not talking
Isn't
about.
that tortious interference with contracts?
If somebody improperly acts with malice and.
No, but where is it on this record?
Sure, Your Honor. This is what I'm getting to, and I just want to, if I can reframe the question, because we're not talking about the tenant's conduct, we're talking about the law firm conduct. And the predicate is found at paragraph 61 on page 30 of the record. Defendant's wrongful and improper independent interference to the caused development was to unjustifiably and repeatedly demand the arrest of an agent when
I'm sorry to interrupt you, but doesn't that claim require interference with a third party? The tortious interference with economic, you're talking about economic advantage claim? That's what you're raising, right?
That's the economic advantage claim, yes.
Don't you have to allege that there was interference, Bailey interfered with third party, and that's the tortious interference?
Bailey
It's not a direct interference.
Bailey acted towards somebody who was at the property to interfere with our economic advantage. That party was there to.
What party?
The
Who did he interfere with?
non-party,
The managing agent, you're saying?
Yeah.
The managing agent.
The managing agent is on your side, though. That's not an economic.
Wasn't the managing agent found to be the person who summoned the police also? So factually, your predicate is incorrect.
No, because it doesn't matter who summoned the police. While the police was there, Bailey demanded his arrest repeatedly over and over again, which was improper because what he was trying to do was effectuate.
Well, it sounds to me that maybe the manager has some claim.
And they make a big deal that he hasn't brought a claim, but he filed a complaint with the grievance committee.
Okay.
And therefore, there was interference, and we need to look at what the pleading is at the time.
If you were that strong on your position, you would have cross-appealed. You have not cross-appealed. I would suggest to you that the claims you raise are difficult claims.
Your Honor, the Miller case made clear that one can lose their underlying causes of action and still not violate the statute, and that's
under the old statute, though, right? Or under the new
no,
statute?
the
Under
Miller
new
case.
statute?
There were two cases, Miller and Aristocrat. I believe in Aristocrat, Justice Moulton was on, and Justice Oing, I believe.
Oops.
You were on the Miller case, and the Miller case specifically held that you can lose all of your causes of action, but still not be violative if it doesn't implicate a matter of public interest. This is a private battle.
But those two cases, correct me if I'm wrong, did not deal with attorneys on the other side.
Of course it didn't, but Your Honor, the conduct that we look at is not our lawsuit. It is the underlying conduct. It is the filing of the ERAP, which is private.
Okay.
It is the call. It is the assisting upon the arrest, which is private, and that does not implicate neither the new statute or the old statute, which is why Justice Krauss got it right when she said the predicate, and this goes to the. This court, which in the Aristocrat case, which they rely on, the court says the strategic lawsuits against public participation, that's the first thing, and then any communication in a place open to the public or public forum in connection with the public interest citing. And what we don't have here is an action by OZU or by the law firm that is in a public forum. It happens.
Was this not in the New York Times? Was this case not in the New York Times?
But that's not the standard. We didn't our predicate.
Wait a minute. Wait a minute. You're telling if the New York Times covers this, correct?
Yes.
And the issue is what attorneys can and can't do to zealously represent their clients. You're saying that neither one of those make this public.
Your Honor, the two actions that we complained about were not the New York Times. That was not the predicate of the abusive process. It was not the predicate for the tortious interference.
No. I'm talking about the anti-SLAPP section.
So allow me to get it out. Yes. Was it in the complaint that this was part of the scheme and this is what he did? The answer is absolutely not. But I would ask this court to take a look at it. But what Your Honor can't do, because this is really what happened, and what this court should not be doing, is send a message to lawyers to say the following two things. Number one, if you've got something sketchy, that you're going to be going over the line. Get it in the press, because once you get it in the press, you have this new protection that this court is going to carve out, because that's exactly what happened. Mr. Bailey.
Or maybe what we should be saying to lawyers is, don't sue your adversary because they are zealously representing their client, just like you are zealously representing
Your Honor, I would
yours.
say if I stepped over the line, somebody should sue me,
Okay.
and somebody should sue Adam Lightman
let's-
Bailey for stepping over the line.
Let's not do invitations there. Thank you, Mr. Schaaf. I got it. We got it. We got it. Thank
We're
you.
going to make it about me, you know, I
We got it.
recognize what we're talking about.
We got it. Thank you.
It's not about you. It's about lawyers,
No.
right?
I agree.
Okay, we're not back at the trial level, guys. Okay. So just to be clear, I mean, we're on equal side, you advocate very strongly, like Mr. Schaaf, your clients too. And I've been downtown where you've got the sharp
I have
elbows
no
too.
issue
on
with
both
his
sides.
zealous representation. I just think that
I
he's
just wanted to
wrong.
make sure that
I
we're not.
want you to address really,
I
I'm
just
sorry.
want to make sure that we're not just beating up
Right.
Mr. Schaaf. You equally have that kind of reputation. Thank you.
But I think the best argument that I heard was that it's a purely private matter. So tell me why that's incorrect.
Sure. There's two reasons. Number one, let's just get to the base part of this. This is landlord harassment of a tenant. That's what this is. There is a direct statute, 235D of the real property law, says you cannot harass tenants by doing exactly what the landlord did in this building. I urge you to...
No, but why is that public? Why, I mean, that happens
Well,
every day in landlord-tenant court. One or the other says, we don't have anti-slaps and all those.
That may be so, Judge. That may be so. But it doesn't morph itself into a lawsuit against the attorney who's representing the client against a very well-heeled adversary who would not take no for an answer. His problem was with the legislature, and I would like to point that to you, Your Honor. So
No, I'm just, again, why is this not a
Because
private
it's still-
dispute
because-
between a landlord and tenant that
because-
happens every day in New York City?
Judge, it's a fundamental chilling of the right to represent your client. And even talking about any kind of media exposure, that's part of the lawyer's toolbox. You can win a case not in court. There are other ways to win the case. So if Mr. Bailey, first of all, Azu said in his affidavit, and it's uncontroverted, he said that he invited the Times to his apartment, not Bailey. That's what he said. That is uncontroverted in this record. And again, I really take umbrage at my adversary going over this complaint. It was dismissed. It was dismissed. He filed a notice of appeal. He withdrew the appeal with prejudice. So any arguments about his complaint is gone. And if you want to look at the complaint, it was all dealing with this so-called media and his so-called managing agent, and somehow that affected a tortious interference with economic prospect. And
It was a private matter until this lawsuit got started, right? I mean, that's essentially
started
it.
off as a private matter, yes, but you've gone.
Well, what I'm saying that you
may-
didn't elevate it to more than what it was until this lawsuit got started. Like,
Well, Judge, look, you might say that his suit against Azu was a private matter. He said there was a breach of contract, but not against Bailey. That's a different animal altogether, because now you're implicating the right to defend your client. That's what's going on, and he wants to chill this. He wanted to intimidate us to give up our client, so the client would leave before there was any adjudication of the holdover proceeding. That's what was going on here. It's so obvious. You cannot ignore the fact of what happened here. Nobody sues a tenant for $85 million when there's a stay in effect, and then sues the attorney a month later for another $25 million.
okay, thank you, Mr. Metz. Thank
Thank
you
you,
both.
Judge.
Good seeing you guys.
Good to go?